Now we're going to hear from Jeanne Kelly, who is a partner in the commercial department of Mason, Hayes and Curran. She has advised clients for over 20 years on matters relating to data protection, commercial contracts, social networking law, which is fascinating, information technology and intellectual property. Hi.
I got the speaking order wrong, so I thought someone about to stand up, so I feel quite relaxed. First of all, I want to kind of declare a conflict with me, like, in that I'm a big fan of social media. I think it's great. I draft privacy policies for a living. It's possible to think of anything more geeky than that. I draft privacy policies for a living. I'm heartily engaged in all kinds of data protection and compliance advice. It's how I pay my mortgage. And I'm comfortable with sharing information online. What I am extremely comfortable with, because I have to be, because it's my job, is managing my privacy controls. So on the various platforms that I use, I think Pinterest is probably the one I'm not active on, and the others are reasonably active on. I use the privacy controls that are within those systems to ensure that I'm not sharing with people that I don't want to share. So if someone who's an acquaintance from school, that I wasn't super matey with, sends me a Facebook friend request, I might accept, might do that passive aggressive thing where you delete them 50 days later, I ask for that. But I might just put them to restricted or acquaintances, so I don't want to be rude. If I really don't know them all, I'm not touching them anymore, I won't reply at all. You don't have to accept every request that kind of comes in. Similarly on LinkedIn, it's one of the conditions of LinkedIn's terms and conditions of service. You're not supposed to contact people you don't know. Sometimes people do and they say, I know someone who knows you, whatever. That's very different. But someone just sending you a request when they don't know you and they live 5,000 miles away, I don't accept those requests because I use it as my kind of virtual Rolodex for people that I met in a business context. So I don't want to accept someone into that network who I haven't met personally. I don't mean that I have to have had dinner with them or that I have to give them legal work, but that I have to have at least met them in some context like in this one. I'm going to just talk a little bit about the general data protection regulation. It is one of the most complex and difficult to negotiate pieces of legislation that we've ever tried to bring in Europe. I say that sometimes in the company of company lawyers who get really competitive about it, and they say that the Recent Companies Act law as well. They're probably right. But we've had 27 years now of pretty stringent data protection legislation in Ireland. We actually had data protection legislation well ahead of a lot of EU countries. And we also have had, as well as 27 years of law in the area, we've got lots of experience around this country of people who've actually advised in this for a living. So we're pretty sophisticated knowledge base in Ireland about that. So layering on top of that now, the EU is talking about bringing in a new law, which will be a common law across the entire European Union. And it has become very politically charged, and it's become quite difficult to pass, I think really, would be fair to say. I'm just going to show you what the law looks like in its current proposal, and this is only one of the proposals out there. This is double-sided printing, and that's it. Okay, so anyone who sells data protection law, really easy. That's just one of the proposals for law. The English regulator in this area, so their equivalent of our data protection commissioner is called the Information Commissioner. They brought out a position paper on one of the drafts of this legislation. Let's just give you a picture of what's involved in this change of law when it happens. The ICO brought out a position paper on one iteration of the draft legislation, picking the top 10 areas that they thought were controversial or unbusiness friendly in this area. Their position paper was 198 pages long, and it looked like we were written with someone with about 5 PhDs. So this is complex stuff. So what are they trying to bring in? Now, bear in mind we already have a law in this area, and there's a good degree of protection of the law as it currently stands, in my view, and lots of companies are not in compliance with the current law. So this is the new law they're hoping to bring in. I'm going to talk a little bit about the background to it. Originally presented in 2010, someone in my office bet me, I bet them really, €100 that it would be passed into law by 2013 or so. I need to collect on that bet. But it originally came in 2010, and the various draft presentations were worked on. Again, the Commission presented it in January 2012 with a quite substantial draft. Through various negotiations, that was approved by the European Parliament in early 2014, and the draft is now at Council for approval. When it is approved, and that is not a straightforward process because lots of countries are very, very vehemently against certain provisions in this new law, something called a trilogue begins, or trilogue, where various EU institutions negotiate the real meat on the bones of this draft legislation. When it comes into law, it'll be a regulation, so there won't be an Irish Data Protection Act as such, there'll be an EU regulation. Will it be enacted in 2015 or 2016? My own personal view is that it's not going to happen in 2015, but it is a number of big name politicians have staked their futures more or less on it passing in 2015. But I think it's optimistic to pass it in 2015 given where it is now. It was actually used just by way of kind of colour, if you like. David Cameron was making a statement last summer, I think to his own kind of party or whatever, at their equivalent of an Ardèche, and used the general data protection legislation proposal as an example of what he called over-legislation in Europe, and as being an example of why a national conversation needed to happen in the UK about leaving the EU. So that's really how emotional this law is. That's the level of attention it's getting. So what are the kind of headline issues in the regulation if it becomes law? There will be much more actively seeking your consent as a user. So in the example that Owen used, where an app is sharing 18 or pieces of data with 18 third parties, you will be being pinged more by those apps to ask you for your consent. Now, privacy is a good thing. It's like motherhood and apple pie, and everyone's massively in favour of it. But the very people who are massively in favour of privacy often find it really interruptive and really annoying when an app or a website persistently harangues you for consent. So it's always this balance you have to strike between getting consent and not making people just switch off, you know. So the consents that you will have to give will have to be much more explicit. You're likely to see, any of you are old enough to remember the Word icon, the old paperclip guy who used to jump up and give you suggestions. Got rid of him, I loved him. And it was going to be new one of him, it's going to be privacy. And you're going to see that as a feature in a lot of websites now, where he'll jump up, Mr. Privacy or Miss Privacy, whatever, and will give you suggestions, or will say, click here to see where your data is going. So it's going to be easier to see where your data is going, but the price for that will be lots of your interactions with websites will become a little bit more difficult, and that's just the trade-off. There will be an approach called data minimization, which in your operations as a business or university or whatever, you'll have to take the approach that, do I need this data, and why am I collecting it? So you're going to have to approach things from a point of view that it should be a minimalized approach and not collecting everything. The right to be forgotten is proposed in the draft regulation. The court has already found that there is such a right and law in any event, although it varies very differently to the court's view of what this right is, and it is a right that exists now. Companies around the world have now got RTBF processes, but there's a sort of a variant of it in the regulation as well. There'll be a right to data portability, so if you are a customer of Fitbit, there will be an obligation on Fitbit to provide its data back to you if you end your relationship with that company in a form in which it allows you to migrate to a new provider if you decide to move to job or wherever the other competitors are. The detail of what that looks like, will you get it in Excel, will you get it in Word, will you get it in a manner that's easy to transfer on a smartphone? Nobody knows. These are things that are all up for grabs. There will be mandatory security breach notification. Some countries already have this. We have a code in this area which isn't really hard law, but is regarded as being very close to a hard law, and that will be at EU level. So when you have a data breach, so say you have a USB stick and you have a number of pieces of customer or student data on it, you bring it home to work at from something you bring it from the office to work on at home, your handbag gets taken or whatever, you may have a very strict, no exceptions, privacy breach regime. And these are time-consuming things. You have to fill out reports, etc. So it's no light obligation. There will be something called privacy impact assessments. These are large technology companies have been doing these for years. I laugh when I see people talk about these as proposals. A lot of companies have done this for years. But there will be privacy impact assessments when you bring out a new product or a new service or maybe even a new college course that says, how am I dealing with privacy in this context? And how am I ensuring that I'm complying with the law? And you're going to have to demonstrate that you've done that. So you won't just have to do it. So it's a bit like kind of health and safety of these things. You'll have to document compliance. So there's lots of kind of business opportunities there for businesses that are involved in that space and how you record that. There'll also be something which has become a bit more watered down as the regulation has advanced, a one-stop shop where in theory you'll be regulated from one regulator within the EU depending on where your central office is, but that has just in recent weeks and months, there's been a layer put on top of that 10 minutes doesn't allow you to go into. So what are the features of the regulation, apart from those kind of high-level things? I mean, I suppose the overarching thing that runs through it is that any data processing that would be carried on in Europe, even if you don't have a corporation in Europe, even if you don't have a presence in Europe, anything that smacks of profiling your customers, you're going to have to get explicit consent for, which means someone's going to have to tick a box at a minimum. There was another proposal in this legislation which was that companies of over a certain size or who processed a certain kind of data, I use the two terms interchangeably, I should think one of these days and stick with it, but you'd have to appoint a data protection officer. That person would have more job security than the CFO has in most companies. They'd have to be at a level where they could query activity of the board, query product design decisions, frankly probably pretty highly paid job, a few grey hairs probably needed to actually carry off the role, and you'd have to have some significant job security over and above what national law already gives you. So my eyes were lighting up. I thought these are going to be dream jobs for any young generation of lawyers. And I think lawyers are great at this stuff, so I thought this was great. Sadly, that's been watered down to become something that's optional, so I'm devastated. There is the biggest kind of kicker in the legislation, if you like, is turnover fines. And anyone in the room who's ever dealt with competition law or competition law compliance will know that when you bring in a turnover fine, so it's all very well to say you'll get in trouble with the regulator, you'll be subject to an audit, you'll be maybe named in the newspapers as being a corporate bad boy about this stuff. What really grabs people's attention is turnover fines. So the maximum turnover fines in this legislation will be 2% of global turnover for a data protection sin in Europe. Contravention regulation. That would be a very extreme example. They would be really looking to make an example of a company by using that, but it'll certainly make people sit up and take notice. Most people have been getting ready for this regulation for at least the last 18 months. I'm just going to mention one other thing that came to my mind when I was listening to Owen's wonderful presentation. I always love watching university lectures because they're way more visuals in their slides than lawyers have. We just have words all the time. But, for anyone who's really interested in telephone data privacy, there is a really wonderful case in the US from last summer called Riley, and it's a Supreme Court US decision about the right to search a cell phone which has been seized incident to arrest. So someone is arrested for one thing, like breaking a traffic light, and as part of that, their phone is seized. And there's a wonderful, about 7 or 8 pages of a part of that judgment where the US Supreme Court Chief Justice John Roberts talks about the level of data that we keep on our phones. And it's a very lyrical judgment, but it's all of that about the apps, and he actually averts to Tinder in the judgment, which is something I never thought a US Supreme Court Chief Justice we refer to it as an app for improving your love life. What I was reading, I was thinking, he's talking about Tinder. And it's a really excellent judgment. I think it's one of the touchstones that people should read about in this area. But my own kind of view on this stuff, that's my own kind of personal opinion, is that the law gives you great controls as it stands on this stuff. The privacy policies of the technology companies, if you use them, give you a really good layer of control as well. So using those two things, secure passwords and common sense, will give you much more protection than you think you already have. So I think that's probably my 10 minutes.
Anytime, I have a few questions, seeing as you asked the finding. We're here in Trinity. A lot of the people who are in college now are digital natives. They likely won't remember a time when there wasn't computers. We kind of live our lives very much on social media. When they go to get jobs, one of the first things that a lot of employers do now will Google or try to data mine the people. What's the I know it's very kind of stringent or kind of loose legal limitations when it comes to how much information people can get and use from social media accounts. For employers who go into somebody's Facebook account and say that, well, you were off your face on alcohol in, Ibiza in 2007, and there's a dreadful picture of you about to punch someone, we're not going to give you the job. I mean, where's the rights there? Because obviously we're allowed to change. There's a right to privacy there. They put them up on their personal Facebook page. the employer couldn't reuse that image because it's their copyright. I mean, how does it work in that sense?
Yeah, I mean, lawyer will always say that it depends, the answer on that. It's great, but it isn't this because we don't have any legislation on this. But I'm talking to my employment law colleagues, and we have debated this at length with them. Their view, and it's just their own view, is that there is nothing wrong per se with looking at someone's profile online if their settings are set to open, etc. But the difficulty with it is you should, as a matter of good employment practice, record that you did. The difficulty with that is if you are doing a recruitment process and you advertise for a senior in-house lawyer, and then you look at people's profiles and you see that someone has kids in their image, or they put in their Twitter profile, I'm a mom or whatever, and then you don't give them the job. The fact that you looked up that may lead them to the conclusion, correctly or otherwise, that you have been discriminatory in your employment practices. So what comes at you if you do that. So it's like anything in kind of data handling. If you look for the data and you maybe shouldn't have, the fact that you did might be used against you. So I would say to people, be extremely careful if you're doing that. What you should be is as transparent as possible. So if you have a job application form, whatever, you should disclose it. You should ideally look for the person's consent. And if you decide to go snooping and you find something that you don't like, you better be prepared to defend an unfair selection action if someone comes at you about it.
And there's been a few cases in the UK, sorry, I'll come back to you 1 second. There's been a few cases in the UK where people who have had bad days at work go home and say the worst words you can think of on their Facebook profile about their bosses and their jobs.
And they don't use the right privacy settings.
But that's exactly it. So I just wonder...
Don't friend your boss on Facebook.
But even if you don't friend your boss... Good tip, it's too late for me, but anyway. But if you don't have the correct privacy settings and your boss just has a sneaking suspicion that you're running foul when you left the office, is the boss within their right then to see, because the information is out there?
Well, it'll depend on whether your company as well has an internet use policy or not, and whether it's included within this. So you might have, there isn't an absolute right to privacy in the workplace. So there are certain limitations that can be put on people's use. When you're doing it at home, I think that's an overreach. I think for someone to look at what you're doing, in that context, is an overreach. Usually the people who ask us this question don't have very robust privacy policies or internal computer use policies, and so therefore they're really hidebound by what they can do.
It's an interesting area.
It is interesting.
I
was going to make 2 points. The first one is your language about digital natives and so on. We're in a transition at the moment, and this is why it's important that we think about privacy issues. We're transitioning, horrible noun becoming verb there, but we're transitioning from a time when privacy was close the door and that was it, to a time when we are all comfortable sharing, and we need to think about that. But one of the consequences of that transition, I think, is going to be that right now, yes, photographs of me being drunk in Ibiza 10 years ago are likely to prejudice my next employer. Okay, sorry to tell Trinity that I want to run away. But my students' employment prospects 20 years' time, based on what they're posting today, that's not going to have any impact because we'll all be so used to what it is that we're sharing. So once we become comfortable with the range of stuff that we're sharing, everybody will be sharing it, and therefore my drunken exploits in Ibiza won't be so unusual. As for the going home and complaining about Trinity on my Facebook account or on my Twitter account, well, first of all, Trinity is not a Disagurian company. There, second use. Secondly, most of the cases that Jeanne was talking about involving employers firing employees or trying to for what they say on Twitter, Facebook and so on, they tend to fail. The most high profile one that succeeded was an internet company, a technology company that had very strong protocols and followed those protocols in firing the guy. But in general, if you don't have the protocols, it's very hard to say that a complaint online is a problem that brings the company into disrepute.
I mean, one thing that I always find surprising in this practice area is that about once a week you get a query where you think, there's no way that could be the query. And someone comes to you and they say, someone's phoned in, this is the query, and you're thinking, no, there has to be more to it. And invariably you find there isn't more to it. Or someone brings out a policy about a particular thing, I'm going to explain what I mean in a moment. An organisation brings out a particular policy and you think, surely there is no need to have a policy around that. The UK Law Society brought out a policy a couple of years ago on social media use, I think it was last year actually, by solicitors, and included lines which they obviously deemed to be necessary to say, if you're doing a family law case, do not tweet saying, I'm in the Royal Courts of Justice court 5, big divorce case on, Russian oligarch, can't wait for my fees to be paid of buying a new car. You know, and they actually have this in the guidance notes, and these are, you know, aimed at solicitors, lawyers, boring people, you know, suits, who, you know, generally are well past college age and shouldn't need to be told that if you're a professional, what you do for a living, the individual clients you work for is private, and anything that could, you know, you might not name a client, but you might say, I'm in the family law court number 5, and there might only be 3 cases on that day. It might be possible for someone to identify, you know, which scars you're acting for, you know. So clearly people are oversharing in that sense in a way that, you know, provides risk if someone decides that there is a need to have a policy around it. So.
So thank you very much for that.